Thank you, sir. Mr. Hayes?
Yes, Your Honors. Good afternoon, and may it please the Court, on behalf of the appellee, Stephen Spire, the bankruptcy trustee in the Brace bankruptcy case. My name is Ed Hayes of Marshak Hayes. I think the one overarching principle that I would like to enunciate today is there is but one definition of community property governing all aspects of California law. In Valley, this court made clear that all property acquired during marriage was presumptively community property vis-a-vis the spouses, unless there was a valid transmutation altering such characterization. That's a good rule to have. It's a bright line rule, and it clears up a number of conflicting prior case law. And in this appeal, the appellants asked this court to find that the bright line rule does not apply when you involve third parties or what they want to extend the third-party language to be to creditors. Instead, they would ask this court to create two different property systems, one governing the character of property solely for purposes of divorce, and one governing the character of property for purposes of creditor rights. The contention, however, is not supported by the plain meaning of various California statutes included in the Civil Code, the Code of Civil Procedure, and the Family Code, that confirm that the character of property is the same in a divorce as it is in debtor-creditor disputes. Specifically, the Civil Code governing property rights and defining property rights in Section 687 expressly provides that the term community property for purposes of California law is that which is set forth.
Counsel, can you hear me?
Yes, I can.
Does Valley govern this case?
I think it absolutely does govern this case, Your Honor. It makes no sense to have two different property systems here. So in the context of debtor-creditor, the Code of Civil Procedure Section 695.010 provides that all property of a judgment debtor is subject to enforcement of a money judgment. So what are those judgment debtor rights? CCP Section 695.020 provides that community property is subject to enforcement of a money judgment. So why is it that a property owner that is married and has a community property interest under Family Code Section 760 for some reason doesn't have a community property interest when it comes to a creditor seeking to enforce their rights under the plain language of Family Code Section 910 that says community property is liable for payment of community debts? And this is even more true in a bankruptcy case where under federal law, property of the bankruptcy estate includes all interests of the debtor in property as of the commencement of that bankruptcy case. A bankruptcy trustee is not a third party to marital property. The bankruptcy trustee steps into the shoes of the debtor who files bankruptcy and has all interests of that debtor in marital property. It would be
Counsel, if I could. So under your theory, what is required for transmutation and how might that differ across different decades? Or is it consistent?
Well, I think what's required for transmutation, at least after 1985, is very clear in Family Code Section 852, and the Valley decision recognizes that transmutation requires a writing and it must contain an express declaration that in essence changes or acknowledges a change to character of ownership or the nature of the property. And the case law is very clear. There are no magic words to provide for a transmutation, but there has to be some level of granting language, if you will, where you're acknowledging you're giving something up. When it comes to taking title as joint tenancy, Frankie Valley makes very clear that the transmutation statutes apply, and therefore what you have to have is some indication in the form of taking title that spouses have parted with some ownership or the character of property. That's simply not the case in joint tenancy. To go back to Justice Liu's comment about what are the expectations of people in this world, the cases over the decades have been very clear. Most people don't understand the implications of joint tenancy versus community property versus tenants in common or any other property ownership statute or manner of vesting. And, anybody with a television, however, understands, or that at least resides in California, that everything a party acquires during marriage is community property. And so it is furthering those expectations that even though title is taken in the name of joint tenancy, it is nevertheless community property. And simply taking the title as joint tenant fails to satisfy the standards set forth in Family Code Section 852, because there is no granting language. There is no express declaration. The parties are not signing and acknowledging they're giving something up. Prior to
Mr. Hayes?
1984. Yes.
Can I ask you, so a central subject of discussion in the briefing is the implications of taking property as joint tenants versus as community property for the circumstance in which one spouse passes away, and whether or not it comports with the reasonable expectation of the spouses that the property in question should have to go through probate versus having a right of survivorship. I'm wondering if we were to accept your argument about the substance of the property holding of the properties in question here, do we have to give the same answer to the question in the context of the death of one spouse? And if not, on what basis might we distinguish the two circumstances?
I think that's a very good question, Your Honor, and it's one that I've spent a lot of time considering. I think that the right of survivorship is clear from the case law to be simply a probate avoidance device. It's a non-probate transfer. It's a vehicle by which you can avoid probate and pass property to a surviving spouse. The case law is also very clear that the other joint tenant has no vested interest, if you will, that the right of survivorship is a mere expectancy that can be severed and terminated at any time. So this situation is no different than holding title to property in a revocable living trust, which the probate code and the family code make clear that you can revoke at any time, so you still own the property. The character of the property hasn't changed simply by virtue of funding it into the trust. It can be revoked out of the trust at any time. You can change the beneficiaries at any time. But if at any point in time one of the trustors or joint tenants die, at that point, that's when the property right vests in the surviving spouse in the case of joint tenancy, or to the designated beneficiary in the case of a revocable living trust. And I believe it's Probate Code Section 104 that provides or recognizes that this is the case vis-a-vis community property and when it comes to trust law. So I think that in this case, too often over the decades, people have conflated the notion of a probate avoidance device with the character of the property itself. I know this was one of the features, if you will, noted by the Ninth Circuit in the Summers decision that somehow joint tenancy was inconsistent with the notions of community property because with the right of survivorship, it doesn't necessarily, it goes to the surviving joint tenant as opposed to what the laws of intestate succession might otherwise provide. But again, that's something that happens upon the death and the joint tenancy not being severed prior to the death. And in the meantime, the nature or character of the property as being community property or marital property has never changed.
So your answer, counsel, is that the significance of taking title as joint tenants in this context then is basically limited to the well, I say limited, but it does confer the essential benefit that spouses want, which is the survivorship benefit. That is not disturbed, but is it your view that there's no other particular significance to joint tenancy title unless there's some further writing that affects the transmutation?
It's absolutely correct, Your Honor. And after spending so much time on these briefs and everything, I firmly believe that that's the case. a lot has been said about the concurrence in Frankie Valli and what it means, and I guess there's three of you here that know exactly what it means because you wrote the concurrence. But I've spent a lot of time looking at that to see what is this language that people want to hang their hats on to say that the rule might be different when it comes to, quote, a third party. And so I want to at least discuss what I've understood the concurrence to mean and why I don't think it means what the appellants say it means. In the concurrence, Justice Chin wrote that the reason for writing separately was to talk about the potentially competing presumptions between Evidence Code Section 662 and Family Code Presumption in 760. And then going further and analyzing the cases that Summers cited, which were Lucas and Brooks, and in Lucas, 662 was never even mentioned by the court. And in Brooks, the facts were much different than they are here. In Brooks, the facts were married properties took title in the name of one spouse during marriage and only one spouse. And that deed did not reference the fact that the owner was a married person. That married person then sold the property to a third party. The non-owner spouse then brought a contest challenging the title brought by the third party. And in reaching the decision that it reached, that the third party took free and clear of any marital interest because there was no indication or evidence that the buyer knew that this was community property, the court said, and for furthering the purposes of stability of title, we looked to Section 662, which would say that the owner of record is also the beneficial owner. I don't think the court in Brooks needed to get all the way there because under Family Code Section 1102, if there is no indication that a third-party purchaser had any reason or knowledge to know of the marriage, that they can still take good title. But then it's with that backdrop that the concurrence in Valli says, so in some context, there may be a need to look at the form of title in the applicability of Evidence Code Section 662, but in the circumstance of Valli, that wasn't such a case. So when you look at that backdrop and the cases analyzed in that concurrence, what I get out of it at least is that vis-a-vis third parties purchasing from married persons, there may be some applicability to Section 662 in some context in terms of whether somebody's a BFP or not a BFP. But when it comes to what are a spouse's rights and property and what sticks do they have in that bundle, and then if one of those spouses files bankruptcy, any interest they have in property becomes property of the bankruptcy estate, including all of those sticks, or alternatively, under the Code of Civil Procedure, when someone's enforcing a creditor claim or judgment, they get to look at all interests of the debtor and property under Code of Civil Procedure Section 695.020. So in this context, the creditor really isn't a third party to this situation. All they are doing is looking to and enforcing their claims against the sticks in the bundle of property rights that a married person has themselves. And so it's a much different situation.
On that point, counsel, is that a reason to limit our decision here to the bankruptcy context? Insofar as it could be said along the lines you just mentioned to be different from a genuine third-party case?
I think that it doesn't make sense to draw a distinction between bankruptcy and creditor rights. I think those are one and the same. Creditors, whether through a bankruptcy trustee liquidating a debtor's interest in property, are creditors in enforcing their claims against a debtor's interest in property. The debtor's interest, the married person's interest, is one and the same. And that's controlled by Frankie Valli that says the character of the property is determined at the time of acquisition. If you're married, 760 says it's presumptively community. If you want to change that result, you comply with the transmutation statutes and you can change the result at that time. So I think these two circumstances are one and the same, and there is no reason to draw the distinction between creditor rights and bankruptcy. And, who knows? And I've spent some time thinking about it, but given my practice is focused on bankruptcy and creditor rights, I don't know if there's any other circumstance that would be different, but I can't imagine in the abstract that having two sets of property systems would ever make sense, and it would just be more and more confusing on top of the decades of confusing and conflicting case law that we already have. So I don't think that that's the way that the law should read when you're declaring what the law should be in this case. I think it's worth noting in my last 5 minutes here that some of the I first went back to where did this idea that joint tenancy somehow magically meant that something was separate property versus community property, where did that even come from? Where did that start from? And the closest I've got to understanding that, I think, was in the Ciberel decision by the California Supreme Court back in the 1930s. And in that case, they look at the vesting statutes that say, under what manner can married people hold title? They can hold title as joint tenants. They can hold title as community property. They can hold title as tenants in common. And from there, they say, because you can hold title as community property and other things, the other things must be something other than community property. And I think that that's the start of all of this confusion, because the manner of vesting, the way in which you can hold title, has nothing to do with the characterization of the property. The vesting statutes in Family Code Section 750 are in a different part of the division than are the characterization statutes in the Family Code starting at Section 760. So these are important concepts to keep in mind, that vesting has nothing to do with characterization. You acquire title with community property while married, it's presumptively community. And the manner in which you hold that title, whether it's in a trust or tenants in common or otherwise, has no effect on your underlying rights as a married person, which furthers the goal of protecting spouses from undue influence. And it's the same result when it comes to creditors or bankruptcy, because creditors or bankruptcy trustees can get to whatever your rights are in property. So I think that that's a very important distinction to note and keep in mind. The other thing that I'd like to mention in my last minutes here is that this whole concept of separate property, joint tenancy interest being separate property, in my mind, I've always thought of that, and I've always heard people arguing that somehow creates a 50% interest in property, which is separate property, and a 50% interest in property, which is separate property. And that's how the 100% of the property is being held. But that's inconsistent with several United States Supreme Court cases that we cited in our response to the amicus brief. One of those is the Kraft decision. And in the Kraft decision, the Supreme Court of the United States noted that there's but one undivided estate, and there are not fractional interests. So under the definition of joint tenancy under California law, and with that a little bit of explanation that this is really but one estate that is owned jointly by two people, but your interest extends to 100% of the property, not some fractional 50% interest, which is somehow separate property. You have an interest as a joint tenant and 100% of the fee interest in that property. And that interest can be changed by severing the joint tenancy. That interest can be changed by a transmutation and the like. But the bottom line is you have an interest in 100% of the property without regard to whether it's community property or without regard or community property in the name of one spouse. It's still community property, and a spouse has an interest in 100% of that property until it's divided. Same thing with joint tenancy property, same thing with property held in a trust, et cetera. So I could go all day talking about this. I've got a couple minutes left. Do you have questions of me? Because I have shared my oral argument time with amicus counsel.
Thank you, Mr. Hayes.
Thank you, Your Honor.
Mr. Meltzer?
Thank you.